Oh, you got one there.
Yeah, I got it.
Oh, he's got a second.
Take us a picture and we all fall asleep. I'm going to watch you in like 90.
Okay, first of all, thanks to John and Jacob Allen from Waltham who are videoing these things. That was a bonus that I hadn't counted on. But I want to say something about the books. The list that I've given you are the ones that I used in this course. Of course, the Pentagon Papers and Noam Chomsky and Howard Zinn's commentary on the essays on the Pentagon Papers. The next book on that list is Ben Bagdikian, and I particularly commend this one to you. It is for sale. We will have the 3 Beacon Press books, 3 of the 4 on sale. Ben Bagdikian is a remarkable guy. I knew him starting in 1957 when I was chair of the advisory board for the denominational magazine, now the UU World, was then called the Register Leader, and Ben was a member of that committee. And he's an outstanding journalist. Interestingly, I did not know until I read Daniel Ellsberg's book that Ben was the go-between between Daniel Ellsberg and the senator who got the papers to the senator. Ben he won a Pulitzer Prize when he was at the Providence Journal, was later managing editor on the Foreign Affairs desk of the Washington Post, and then later taught journalism at he was the head of the journalism department at Dean of the Graduate School of Journalism at the University of California in Berkeley. He's an outstanding guy. He's written, Beacon's published at least 2 of his books. He's been for years a critic of media and the way they've conducted themselves, and he's just a great writer. And he's got, although just 1 chapter or 2 chapters of this book are on the Pentagon Papers specifically, but that whole memoir is an absolute delight. He's written something over 20 books. And that's available at $16, Beacon Press, and I've got some here and more at home. Then, of course, there's Daniel Ellsberg's book. The Gardner and Young book I'm using a lot in the last session because they draw directly the parallels between Vietnam and Iraq. The next 2 books are by Rashid Khaladi, again, both Beacon Press books. The Resurrecting Empire is available at $14, and The Iron Cage is available at $15. And again, I've got 3 here tonight, but I've taken on consignment 10 of each of those 3 books. Khaladi, we will hear next week. He gave the Ware lecture at the General Assembly, which I think is one of the most outstanding Ware lectures that I've heard in the many years I've been going to GA. He is an historian par excellence, and he picks up on what I think will be one of the main thrusts in my last session in our failure to read and understand the history of the Middle East and the mistakes that we make there because we don't know beans about the history. And he will talk about a lot about that in his Ware lecture, and both of these books are on that topic. The Resurrecting Empire is the way the U.S. has sort of stepped in and replaced the empire building of France and England, mainly England in the Middle East, after they sort of faded out and the U.S. stepped in and resurrected their empires. And the Iron Cage on the whole question of the Palestinian statehood. So those, again, are all 3 available. You can get them tonight. I suspect after you hear Khaladi, there will be good sales of that book. Robert McNamara's book, excellent coverage of his position, though he just doesn't get it. He keeps saying over and over again, we didn't know. But the question is, why didn't he? Because the information was there, and for the same reason that we didn't know about the nuclear material coming from Niger. We didn't know about the weapons of mass production. We didn't know. We ignored deliberately the information that was available. And so but McNamara gets into his defense, which, you know, I consider him probably the most capable Secretary of Defense that I know of, and yet he had this tragic flaw. Alison Thropp's book, Beacon Press and the Pentagon Papers, I did have one more of those that I was going to bring and forgot it, but we don't have any more available, but you can read that online. If you go into Google and type in Beacon Press and the Pentagon Papers, you can read that whole booklet online. Bob West's book is back there. Bob was president of UUA. You saw him last week on the panel tape. And this is a book that Bob wrote about the years that he was president of UUA. There's one chapter in there on the Pentagon Papers. Susan Wilson, there are several books, copies of her booklet back there, and those are free. I encourage you to take them if you're interested in the history of Beacon. There's a lot more in there than I could give you in that short lecture last week. Then in addition, there are the two versions of the Supreme Court document. It's the one double case that are back there on the table. So that's the list of books that have been used in this preparation. So we'll get into our topic tonight, picking up where we left on after the first lecture with a cliffhanger of that telephone call that I got on July 19 from Goben Stair. We've got the Pentagon Papers. We think we should publish them. What do you think? And very quickly, the next day, 5 people were unanimous in their agreement that we should publish. I was one of those 5 as chair of the Beacon board. Goben as the director of the press was another. Arnold Tovell as the editor of the press was a third. Bob West as president of the UUA was a fourth. And Ray Hopkins, the vice president of the UUA, was a fifth. And that agreement was done with no dissent at all. Very quickly we agreed we should publish. At that point, I think none of us, or I should say all of us, thought that publishing classified material was a crime. And as you'll see in the lecture tonight, turned out it wasn't. We had no idea. We knew the Nixon administration would come down hard on us as they had on the New York Times and other newspapers. We did not know what they would do. But we were all aware of the fact that we could wind up being convicted of a crime. But it turned out that wasn't the case. 15 days after we made that decision, Senator Gravel announced it. Meanwhile, we were busy making our own publishing plans. This meant that we had to get bids on typesetting, and as you can see, there are 4 big volumes, some 2,000 plus pages. And we had to go to a printer and get bids on this without the printer knowing what it was we were having him bid on. The printer with the lowest bid, after the senator's announcement, withdrew his bid. He gave us the reason not that he did government work, but he did work for a number of companies that held government contracts. He was afraid that if he printed the Pentagon Papers, the government would insist that those companies take their printing business elsewhere. His bid was $10,000 lower than the next one, and thus the chilling impact of potential government threat cost us $10,000 before we ever lifted a finger. That announcement by Senator Gravel and later by the Beacon Press resulted in a phone call at home to Goben Stair from President Nixon. I attempted without success to obtain a written transcript of that call from the Nixon library. They said it wasn't available. I don't know how people get those tapes, but tapes are available some way. But all we have is Goben's recollection as he remembers it. And what he remembers was that Nixon said, "Goben, we've been investigating you around Boston, and we know you're apparently a pretty nice and smart guy. I hear you're going to do that set of papers by that guy Gravel, and then going on to suggest that he should not do it and that he would be in trouble if he did. In anticipation that the government might act against Beacon, and we thought they surely would, we right off the bat spent over $60,000 in legal fees to prepare a defense, even though the government had not yet acted. Those legal expenses continued to grow even after the government eventually, and you'll see at the end of this lecture tonight, stopped the action but did not close the case. They just suspended it, left it dangling. We didn't think they planned to take any further action after they lost the Ellsberg trial, but they just left it hanging there, not pursuing it but not dropping the charges, and we had to continue retaining attorneys for some time. My greatest concern was always that we could be completely exonerated by the courts, as I eventually believed we would be, though not initially, and still be bankrupt if the government chose to pit its vast financial resources against our small denominational publishing house. I wrote a sermon, I think it was in 1973, I believe, entitled The Mouse That Roared. You remember that movie by Peter Sellers? Because this is the way I felt. We were a tiny little publishing house taking on the federal government, and they could just beat up on us and lose every case and still clobber us. We could go to court again and again, and each separate issue of continued litigation, winning every court battle and be destroyed by the process. That didn't quite happen. But the government threat was obviously more than just its potential of being there. 1 month after Senator Gravel's announcement, 2 men appeared unannounced at Beacon's offices saying they were part of a, quote, special team working on the Pentagon Papers. They declined to give us their titles, but they made a point of saying that they were from the Defense Department, not the Justice Department, which seemed a little odd. Our officials declined to meet with them without our attorneys being present, and at the suggestion of Burnell O'Brien, Goldman Stairs' secretary, they did the tour of either Old North Church or King's Chapel, I've forgotten which, while awaiting the arrival of our attorneys. When our attorneys got there and met with our press officials, the 2 men first demanded that we return the papers. We declined. They then wanted to know specifically what we intended to publish. We declined to give that information as well. This was on a Friday, and they made an appointment for the following Monday at 9:30 in the morning for 3 legal representatives from the Pentagon to meet with us. At 9:15, a phone call from the Pentagon canceled the appointment. The day after that, the government announced that they were publishing an expurgated version of the papers, but denied that it had anything to do with the fact that we were publishing them. I'm clearly sure that they were trying to undercut our publication, but that version was very, very censored, very expurgated. The Times noted that this is a quote from the New York Times, some congressional sources noted that the decision to publish the censored version came with unannounced suddenness. That heavily censored version came out on October 10th. We published the papers on October 22nd. 5 days later, on October 27th, unbeknown to us, 2 FBI agents went to our bank in Boston and asked to see both UUA and Beacon Press bank records. The 2 were at that point separately incorporated. They are not now. That Beacon is a department of the UUA, part of the Department of Publication. But then it was separately incorporated, and of course has then, as it does now, separate bank accounts. They wanted the bank records of both the UUA and the press for the period from June 1st to October 15, 1971. They had no legal authorization for such a search, and the bank refused to give them the information. 2 days later, they returned with a grand jury subpoena, and the bank acceded to their request. And here we run into one of the oddities of all of this. depending on how much you know about grand juries, and Jeff, you may be able to help us out on this. Because this was a grand jury procedure, we did not have to be advised of the action or given any opportunity to contest the government's right to examine those records. They spent 5 days at the bank going over the records. We didn't know it was even happening until November 4th, by which time they had finished their search and left. Later in the court case, they said they did not copy any records nor find any evidence related to the Pentagon Papers. But the FBI had access to the record of every check that went in or out of the UUA and Beacon Press during that 4.5-month period. If you made a donation, they were able to see a record of it. Another oddity in that is that the day after that grand jury issued the subpoena, the grand jury itself was enjoined from any further investigation of the case, because the courts were then in process of determining whether Senator Gravel's congressional immunity, senatorial immunity, extended to Leonard Rodberg, his assistants, and extended to Beacon Press, since we had published the papers at his request. But the FBI had gotten their subpoena 1 day before that happened, and they proceeded with their examination of our records in spite of that injunction. After the Court of Appeals ruled that the senator's immunity did not cover Beacon Press, and even though that decision was being appealed to the Supreme Court, the grand jury issued another subpoena for our bank records to be brought to the grand jury. This time we did know of the action and sought an injunction against it. The government withdrew the subpoena rather than face a legal test of the issue, and the judge advised us that he would not allow another subpoena to be issued without giving us a hearing to contest it. Before the government withdrew that subpoena, however, they had filed an affidavit, and I have a copy of that here, filed an affidavit in opposition to our brief, and doing so had to reveal to us for the first time the charges that they intended to bring against the UUA and Beacon Press. They said they intended to prosecute the officials of Beacon Press for a violation of 3 criminal acts, and this is quoted from the affidavit. 1, receiving, concealing, retaining, and conveying stolen government property. 2, receiving, retaining, communicating, and failure to deliver documents relating to the national defense. And 3, interstate transportation of stolen property of a value in excess of $5,000. In addition, we were to be charged with conspiracy to commit such offenses. This came as a shock to all of us. Strange indeed. 2 of them involved stolen government property. But in the Gravel immunity case, the government had conceded that the senator was within his rights in placing the material into the Senate record and thus in the public domain. And the copies we had were not government property, but copies that Daniel Ellsberg had made. I was surprised that nothing in the charge said anything about publishing classified material. That was where I thought we were in greatest jeopardy, where we might all wind up in jail. But Senator Fulbright then pointed out on the floor of the Senate in a debate on the Pentagon Papers, and I learned then for the first time, as did many senators and did all of us at Beacon, that there was in fact no law against publishing classified material. To get a criminal conviction for publishing classified material, the government had to prove that the publication did or could have endangered national defense. And that's why the Ellsberg-Russo trial in early 1973 focused not on publishing classified documents, because that wasn't a crime, but on conflicting testimony as to whether the publication endangered national defense, rather than on the question of being classified material. And indeed, one of the reasons of many that the case against Ellsberg was eventually thrown out of court was that his attorneys said, hey, there are 47 typewritten volumes of this these Pentagon Papers. We can't build a defense based on all of that material. The government has to say, what in there did they think endangered national defense by its being published? Endangered national security. The government declined to do that. And that's one of the reasons that they lost the case with Ellsberg. A major issue involved in the Pentagon Papers case has far broader ramifications than just this case, and which I believe is frightening in its implication for justice in America, and that is the abuse of the grand jury procedures. I was not aware, and again found out that most Americans are not aware, of the purpose of a grand jury or of the rights of those called before a grand jury. The grand jury system is secret. It was set up to protect defendants from prosecution harassment when there are not reasonable grounds for prosecution. It's a procedure that takes place behind closed doors to require that the prosecution demonstrate that it has reasonable and sufficient evidence to justify an indictment. It is not a trial. The defendant may not even have legal counsel present in the grand jury room. Rules of admissibility of evidence that apply in a trial, but not in a grand jury hearing. The prosecution doesn't even have to tell you what charges they're investigating or who they are investigating. Yet you have to answer those questions or face contempt of court if you refuse. But the grand jury has been used and is still being used to some extent, although some of these excesses were corrected as a result of this Pentagon Papers case, was used for precisely the opposite reasons for which it was created. It was created to keep defendants from being smeared with evidence that was purely conjecture, all this kind of thing that wouldn't stand up as under rules of evidence in a courtroom, but could be brought into a grand jury. But by distorting its use, instead of safeguarding the rights of defendants, the grand jury procedure was used to get around rules of evidence and gather information that could not be gathered in a trial, and then using the information in the trial. The Nixon administration flagrantly abused the grand jury process by gathering evidence without the rules and protections of a trial court, and then making that evidence public and using it in the trial. Those abuses eventually led to 2 Supreme Court decisions in the 1980s protecting the secrecy of grand jury evidence. Ellsberg-Russell trial is a case in point. After they had been called before a grand jury in Los Angeles and indicted, that grand jury hearing was then closed. It had done its work and, having handed down an indictment, could no longer legally continue its investigation. Ellsberg and Russell were bound over for trial, where their rights would then be protected by legal safeguards. However, when the U.S. Supreme Court halted the investigation of Beacon Press by the Boston grand jury, pending a ruling on senatorial immunity, the government moved to have that case expedited, that is, moved ahead in its turn on the Supreme Court docket. The reason given for requesting that expediting was that the government wanted to reopen the hearings of Beacon Press before the Boston grand jury in order to gather additional evidence for the Ellsberg-Russell trial. It would have been illegal to continue a grand jury investigation of Ellsberg and Russell once they had been indicted, but by using the Beacon hearing, the government hoped to circumvent that legal safeguard. On January 11th, during a press conference at Beacon Press, Goben Stair, the director of Beacon, was served with a subpoena. 45 minutes later, the agents returned to withdraw the subpoena. And 15 minutes after that, they withdrew the subpoena to our bank. 10 days later, on January 21st, Goldman was subpoenaed again to testify at the Ellsberg-Russo trial in California. The odd thing about all of this was there had been absolutely no contact, zero, between Beacon Press and Daniel Ellsberg until the fall of that year. Remember, Ellsberg gave these papers to Ben Bagdikian. Bagdikian took some of them to the Washington Post, took another set to Senator Gravel, and it was Senator Gravel who eventually got those to Beacon Press. But we had no connection whatever for Ellsberg, but they wanted Goldman to testify in the Ellsberg-Russo trial. Meanwhile, the court case on congressional immunity was making its way through the courts. The question was the senator's aide, Leonard Rodberg, immune from prosecution because he was working in the senator's behalf? Was Beacon Press immune because we published the papers at the senator's request? On January 7, 1972, the three-judge Federal Court of Appeals ruled that Senator and his aide were immune under the speech and debate clause of the Constitution, but that Beacon Press was not, and therefore could be questioned in court by a grand jury. Both sides appealed that decision to the Supreme Court. The senator wanted to have Beacon Press included under his senatorial immunity. The government wanted to have Leonard Rodberg excluded as senator's aide, and only the senator himself protected by senatorial immunity. The Supreme Court ruling of January 29, 1972 on that issue held in a 5-4 vote that unless the actions of Rodberg, Beacon Press were in conjunction with a legislative act, they were not immune from prosecution, noting that criminal acts were not protected by the speech and debate clause of the Constitution. One of the ironies of that was that ruling of the Supreme Court took place just 12 days after 5 men, the plumbers, were arrested for breaking into the Democratic National Committee headquarters at the Watergate Hotel. Criminal action. And incidentally, 3 of the people who prosecuted the case on behalf of the Nixon administration wound up being convicted. One of those convictions was set aside because of a technicality, and the government opted not to retry him. But the 3 people that were after Beacon were all convicted. But basically, the community gave immunity to Rodberg if his actions were such that, had Gravel done them, he would be immune from prosecution. Beacon, however, was another matter. The court said, and I quote from the majority opinion, "Private publication by Senator Gravel through the operations of Beacon Press was in no way essential to the deliberations of the House." I don't know why they use House instead of Senate. "We cannot but conclude that the Senator's arrangement with Beacon Press was not part and parcel of the legislative process." But these documents were in the public domain, in the congressional record, but unavailable for anyone to read because Senator Jennings Randolph of Virginia, West Virginia, I've forgotten where, refused to authorize for payment of a stenographer to make the public record. How could they be part of a legislative process when no one had access to them? Even though the senator had introduced them into the record, they weren't there to be read. And yet we were told that Beacon was not publishing them, had nothing to do with the legislative process. The decision of the court refers again and again to the relationship to legislative acts as a standard for immunity. But how can anyone relate a legislative act to a document that they don't have? The appeals court had protected Rodberg's immunity, quote, "to the extent that a congressman has a responsibility to inform his constituents," end quote. But the Supreme Court ruled that we cannot, quote, we cannot immunize criminal conduct or frustrate the grand jury's inquiry into whether publication of these classified documents violated a federal criminal statute, end quote. Justice Douglas, in dissenting, wrote this: "The story of the Pentagon Papers is a chronicle of suppression of vital decisions to protect the reputations and political hides of men who worked an amazingly successful scheme of deception on the American people. They were successful not because they were astute, but because the press had become a frightened, regimented, submissive instrument, fattening on favors from those in power and forgetting the great tradition of reporting. He continued, to allow the press further to be cowed by grand jury inquiries and prosecution is to carry the concept of abridging the press to frightening proportions. What would be permissible," he continued, "if Beacon stole the papers is irrelevant to today's decision. What Beacon Press plans to publish is a matter introduced into a public record by a senator acting under the full protection of the speech and debate clause. In light of the command of the First Amendment, we have no choice but to rule here that government, not the press, is lawless," end quote. The government did not contend that what the senator did at the subcommittee meeting was illegal. They conceded that what he did placed the material in the congressional record in the public domain and open to the public to read, even though they couldn't because the material wasn't printed. But they held that neither the senator's aide nor Beacon Press were immune under the speech or debate clause when they distributed the public material to the public. And even though the government had no intention to prosecute the senator, a dangerous precedent was set. To say that a senator may make information available and in the public domain but may not distribute it to the public doesn't make any sense. To say that informing the public on governmental activities is not part and part of the legislative process is to destroy one of the most important functions of a congressman in a democratic society. In Justice Douglas' dissent, he also said, quote, "The informing function of Congress should be preferred even to its legislative function," end quote. It is a narrow interpretation that is clearly not stated in the speech or debate clause, and it appears to limit privileged actions by a congressman to those actions which bear directly on bills before or being introduced in the Congress. It is a sad day for America when a congressman cannot communicate freely with the public about vital matters of government action. I take pride in the fact that we published the Pentagon Papers. I do not believe that we violated any law. What was in the papers did not endanger national security. Senator Gravel, before he gave the papers to us through Ben Bagdikian, had deleted some material that he thought was sensitive to national security before giving us the papers. And we said that we would consider Defense Department requests for deleting additional material, which if they requested it, that we would seriously consider it, but they declined to do that. But the papers were essentially not military. They were political. They covered the decision-making process by which we became involved in a tragic war. They were kept secret for political purposes, not for military security. The function of democracy depends upon the accountability of elected officials for the decisions they make. The people do not have the basis for making their election choices if the political decisions of those elected are kept from the public. If we are to avoid such tragic wars in the future, which is why McNamara, Secretary of Defense McNamara said he created this study for the Pentagon Papers. We must study the mistakes of the past and learn from them. But we cannot do this if a bureaucratic barrage of classified stamps conceals our own history from us. Finally, a question is, why was President Nixon so vehemently opposed to the publication? This was essentially a mess created by Democratic administrations, not Republicans. In one of those infamous White House tapes made by the Nixon administration on June 13, 1971, the day the New York Times began publishing excerpts from the papers, Henry Kissinger phoned the Oval Office from California, and the Kissinger tape reads as follows, quote, "In public opinion, it actually, if anything, will help us a little bit, because this is a gold mine of showing how the previous administration got us in there. I think they outsmarted themselves because they had sort of tried to make it Nixon's war. And what this proves is that if it's anybody's war, it's Kennedy's and Johnson's. So that these Democrats now bleating about what we're doing wrong, this graphically shows who's responsible for the basic mess. This is an indictment of the previous administration," end of quote. Nixon obviously didn't buy that argument. So what was his concern? Several of you are old enough to remember that election of 1968 when Nixon was first elected president. You may remember that one of the key parts of his campaign was a, quote, "secret plan," end quote, to end the Vietnam War. He said he couldn't give details because that would tip his hand. The details turned out to be, as we discovered in the Nixon administration, to escalate the bombing and to expand the war to the entire Indo-Chinese peninsula, including Laos and Cambodia. The Pentagon Papers study cast strong doubts about the workability of such a policy, and it would have undercut Nixon's strategy. On May the 11th, 1975, the judge in the Ellsberg trial in California dismissed the case with these words, quote, "The totality of the circumstances of this case offend a sense of justice. The only remedy available that would assure due process and the fair administration of justice is that this trial is terminated and the defendant's motion for dismissal be granted and the jury discharged. The case is terminated." But where did that leave Beacon? 8 days after the dismissal of the Ellsberg-Russo trial, the Minneapolis Star reported, "Officials of the Unitarian Universalist Association do not now expect the federal government to reopen an investigation of the denominational publishing firm in the Pentagon Papers case. While the association has heard nothing about the investigation since last summer, a spokesman told Religious News Service that he assumed the dismissal of charges against Daniel Ellsberg and Anthony Russo in Los Angeles meant the case would not be pursued on the East Coast. And indeed it was not, but never dropped. Still to this day, nobody ever officially dropped the case. Our support, both financial and moral, doing all of this was massive. The Association of American Book Publishers, the American Library Association, Union of American Hebrew Congregations, Central Conference of American Rabbis, National Council of Churches, Synagogue Council of America, U.S. Catholic Conference. Interesting, since we had enraged the Catholics a few years earlier by publishing Paul Blanchard and Emmett McLaughlin's books. And the Catholic Conference offered legal assistance to our attorneys, as well as many UU churches across the continent. We got letters from churches and checks from churches all over to help with the defense. The publishers raised quite a Publishers Association and individual book publishers raised a lot of money in Beacon's defense. And that's where we leave it. Okay, questions, comments, and let me ask you to use the microphone again. Okay. I'll just pass it back to the back row back there.
How much in total did it cost?
I knew you were going to ask that, or somebody would, and I don't know. I don't know. It was several $100,000 back then, which was a lot of bucks, but I don't know the bottom line. Plus the cost of publishing, because we knew the day we decided to publish this that it was as a commercial venture, a loser. I mean, who's going to go buy those 4 big volumes at 40, 45 bucks a piece? Or even the paperback. We issued it in paper and hardback at the same time. That's a book that nobody's going to buy and sit down and read. Sales went to libraries for research. In fact, many of our churches bought copies of books to give to libraries. They'd buy a set and give them to a library because that's where it was really going to get used. But I really don't know, Mary Ann.
How much did it cost to publish? I mean, I was asking really, the first question was about the legal defense.
Yeah.
But how much did it cost to publish?
That I don't know either. No. Geb over here, we'll pass the mic over. You have to wait till you get the mic. My hearing is such that the reverberation in this room and this little electronic is a wireless mic to my earphones. No, turn it the other way. The cord way pointed toward you. Yep. Now the point the cord toward your mouth. Yep. That's good.
I guess I'm curious as what your life was like and the members of the board during all of this time. What was the personal impact upon you? And I mean, you must have been on pins and needles and what have you, and how did you survive, and how did the group help itself?
Well, we were nervous until we got that statement from, the main thing that I felt we were in personal jeopardy was over being charged with a criminal act of publishing classified material. And when Senator Fulbright surprised all of us by, and a lot of people in the Senate didn't know that saying there's no law against publishing classified material, that was a big relief for us because we thought, other than that, we were not in any legal jeopardy because this stuff was in the public domain. And I didn't think we were in jeopardy. We were nervous. My first meeting with the investigative reporter for New Yorker magazine,
Seymour Hirsch?
Seymour Hirsch. I had an interview with him. He was a friend of mine in Westport, Connecticut. I didn't even know he was an investigative reporter. And she said, there's a guy that's interested in what you're doing with the Pentagon Papers. And he came out, we had dinner at her house with him, and I was completely naive and innocent. I could have put my foot in it, but fortunately didn't to that interview. But yeah, we were, once Senator Fulbright cleared the thing on the criminal charge of classified material, the rest of it, we were more worried about its impact on the UUA and the press because of the cost of one little denomination pitted against the resources of the federal government. And our biggest fear was that they would just simply hassle and hassle and hassle and bankrupt us. And they very nearly did. There was a period of time some years after that, but Beacon was left in such jeopardy and the UUA in such jeopardy that There was one point when they talked about selling the press. Fortunately, they didn't, and it's now recovered and operating pretty solidly financially now.
Ed, I think you need to repeat the question so you can hear it.
Oh, okay.
We may not be able to.
Thank you.
I think it's checked.
Point the bead towards your mouth, Jeff.
B.
The bead towards your mouth.
The end of the string's coming out of towards your mouth.
Okay. My recollection is that the Congress purchased all of the Nixon papers, everything. And though they may reside in the Nixon Library, it's all owned, by people. And that, I don't know if you've made, or UUA has made a formal request, for all documents related to actions that were taken by the Nixon administration against, Beacon Press, etc. But it seems to me that that the Nixon library would have to be forthcoming with all documents because, amongst other things, as I say, the documents are owned by the people of the United States.
Is that true of all presidential libraries or just that one?
I don't know about others, but I know that it's true of the Nixon Library. I know that there was a lot of negotiation as to the purchase price, and eventually they haggled about it, and eventually a price was determined. But they were purchased, a check or whatever, money was transferred to, I don't know whether it was the Nixon family or somebody representing the Nixons for all his papers.
I did
I'm almost
not know
positive
that.
that's the case.
I was not aware of that. Maybe I should go to Senator Kennedy or somebody for help in trying to get some of those documents.
Conversation.
And do you know if any of that information that was obtained about the UUA that had nothing to do with Beacon Press was ever used against people, either to, investigate them for finances or, there was certainly talk of back then of, the IRS investigating people's taxes and because of people's political beliefs and that sort of thing.
No, we have discovered no evidence of that at all. We do know that in the operation of the protesting against the Vietnam War and the Civil Rights Movement, Dana Greeley, who was president of the UUA then, got audited 5 years in a row by the IRS. But to the best of our knowledge, we've seen no repercussions from that investigation into the Pentagon Papers. No evidence that any document was copied. And I think, as far as my guess is that the government was not lying when they said they did not copy any documents and take them out. They were looking for information that we had bought the Pentagon Papers, that was some transaction involved financially to get them. And I don't think they didn't find that, and so I think that was the end of it.
What about Daniel Ellsberg's life? Has that been compromised, do you think, from that time on? Or?
What about Daniel Ellsberg's life? Has that been compromised from that time on? No. You were not here the night we had the panel, were you? Okay. One of the DVDs is a panel of Daniel Ellsberg, Senator Gravel, and Bob West. And I think Ellsberg's stature has been enhanced. He's gotten awards. He's gotten a lot of plaudits from this. And no, anything but. Okay. Now, I want to say two other things. One, and then I want to introduce John Allen. Next week we will hear Rashid Khaladi giving the Ware lecture on the whole issue of Middle East and U.S. history and our failure to get that. A very excellent lecture. The two big events at the GA were the Ware lecture and the panel that you saw last week. And those were probably something in the neighborhood of 3,000 people attending each one of those. The other thing is that in addition to these books, those two DVDs are available if you want them. And John Allen from the Waltham Church is making DVDs of my 3 lectures, and he can say something about their availability.
Okay. Yes, well, my son Jacob, who is now videotaping me.
Hello.
All right, hi Jake. And I are making videotapes of Ed Lane's lectures, and you can get copies for yourselves or for anyone else who may be interested. So thank you.
As you know, Sarah Gibb, now Sarah Gibb Millspaw, our former student intern, is the head of the Adult Programs Department at UUA. She actually works from California, where her husband is a minister there. They are, I don't know what state they are candidating for the ministry in the church in Winchester. And maybe, of course, moving back there. But what they're doing is looking for a single ministry divided between 2 people so she can still work part-time as a minister and part-time for the UUA. So I have sent an email to Sarah and to Helen Atwan, the director at Beacon, and Kay Montgomery, the executive vice president at UUA, indicating what we've done in this course in putting the 5 sessions together, with the possibility that they might want to use these 3 DVDs made here plus the 2 from the General Assembly as a packaged adult programs course. So whether anything will come of that or not, I have no idea, but that's part of what John's talking about that's in the works. So we don't know what kind of distribution this will have. Okay. Good, we're out early tonight. And do take any of the books you want if you want to buy them tonight. And the ones down on the last table are freebies.
Chairs away, please.
You want this one?
I wanted to.